Good morning. My name's Nick Allard, and I'm the Dean of the best law school in Brooklyn. And you know, Brooklyn's the biggest and most vibrant borough in the leading city in the greatest state, the most wonderful country, so that's not bad. So welcome and thank you all for coming to a program today that is very near and dear to our heart. I should point out that I am the Joseph Crea Professor and Dean of the Brooklyn Law School, and Joe Crea, who this month turns 99 and still teaches commercial paper well, is with us. He was in the back of the room for some reason, but I'm sure he'll be making the rounds. So Joe, as a veteran, who has something to say about how law can make a difference in not only a young lawyer's life coming out of the military, but helping to make a difference to other people, is here with us today. And I'm determined, and I think all of us here are determined to be able to improve conditions for our veterans, and that will happen. We'll get it right. And if you don't believe me, just find Joe Crea in 25 years and ask him how he did. Now, there's some people who look at my well-turned-out GQ Ivy League exterior and assume that I was born and grew up with a silver spoon in every orifice. That is not the case. My father was the first person in our family to graduate from college. I'm the second. My father was only able to go to college because he joined the Army and earned the GI Bill, and after World War II was able to go to little Gettysburg College right outside of where he grew up in Waynesboro, where he and his father and his grandfather had worked as machine tool operators. That opportunity was important, but his dream of becoming a doctor didn't come true. He often said that by the time he got into medical school and was first in his class, if he had only had $1,000, that he would have been able to have become a doctor. And that never happened, and he did all right, and the rest is history, as you say. But we appreciate fully the special struggles, the special opportunities that service to our nation through military service imparts on people. So I just mentioned that personal history because I want to convey to you that this effort today, not just from me, I'm not a leader, I'm just holding on and following here, but for so many other people in our community, it's a very special, very personal commitment. It's not an abstract, theoretical thing. Today's event is extremely important. New York is the home to about 250,000 veterans at least. We know that veterans have a complex array of benefits and challenges facing them and need for assistance and support, and they bring a lot to the table to benefit our community. It's a wonderful investment. It's not just compensation for their service. It's a wonderful investment in people who have a lot to contribute. So this program today, which is designed to address those array of issues and that brings to us a number of civic leaders, scholars, practitioners, and other people dedicated to this issue. It's a very important conversation that will be continuing at this law school. You know, there's a lot of noble callings. I've been talking about this recently a lot, about why it makes a difference to enable people to become lawyers, go to law school. And that's because it's a noble profession. People forget that Sir Thomas More or Gandhi were lawyers. They forget that Clarence Darrow, Abraham Lincoln, Thurgood Marshall. They forget that Sandra Day O'Connor, Sotomayor are lawyers when they're making their contribution. They sort of distance themselves. And one of the most noble things that people can do is to assist and clear the way for veterans as lawyers, helping them. And so that's why this topic today is something more than a technical legal discussion. It's not surprising this conversation is taking place in Brooklyn. You know, the Brooklyn Navy Yards, for example, has become a huge center of jobs for veterans. The 200 students have internships there that lead to jobs, and about 20% of the people at that incubator there for businesses are finding jobs, and they're at least $12 an hour and up, and most of those people are in low-income housing. So it's not a solution, but it's an important gateway, and this is the kind of activity that's taking place in Brooklyn. So I'm going to express special appreciation to our young trustee, Tyler Korff, who has made today's program possible. He is going to be continuing support, and we'll be next year having further programming on this topic. Professor Meyer has led this conversation. I see other members of our faculty here, which I'm very glad to see. Our event staff is incomparable, led by Linda Harvey in the back, and Liz Alper, and all the rest. Whenever I start to name people, you always get in trouble, but I want them all to know how grateful we are for making this possible. But most of all, we're very grateful for you to showing your interest and commitment to this issue by your attendance. I wish I could be with you this morning. It's exhausting, but I've been chopping prices. I don't know if you've noticed that. And I'm going to be spending the rest of the morning trying to give religion to the rest of the people in the country who are involved in legal education, because, you know, Brooklyn Law School is way out in front on this. Somebody said to me, well, that's not that much. You talked about a 15% tuition reduction. It's about $24,000. You know what? Guilty as charged. It's still expensive. But for anybody that says $24,000 matter, they're the ones that don't need it, you know? It's a start. We're doing what we can. We're combining that price reduction with affordable housing in this building. Generous loan repayment. We're going to be spending more money for need-based scholarships. And we're doing everything we can support. I wish it was sooner, I wish it was bigger, but that's what we can do. And so we're going to be plowing ahead and hopefully be doing more. But really, this is an issue, like this military issue, that's not about Brooklyn Law School, it's not about New York. This is an issue of national importance. So again, I thank you very much for your support, your participation, and I wish you all the best. Have a marvelous program today. Bye-bye.
Thank you, Nick. So my name is Minor Myers, and I teach here at Brooklyn Law School, and I'll be moderating our panels later today. But right now, my job is to offer a brief introduction of our speaker, Samuel Spitzberg. Samuel Spitzberg is a graduate of Hofstra University School of Law and was a tax attorney before he joined the Army in 2001. He served on active duty from 2001 to 2005, and again from 2006 to 2007. While on active duty, Mr. Spitzberg served as a legal assistance officer, a prosecutor, and defense counsel in Texas, Virginia, and in Iraq. His most prominent case was the United States versus Lieutenant Colonel Stephen L. Jordan. Colonel Jordan was the only officer charged in the Abu Ghraib prison abuse scandal, and Mr. Spitzberg successfully defended him at court-martial. Mr. Spitzberg is currently the General Counsel with the New York State Division of Veterans Affairs. The Division of Veterans Affairs represents the interests of all of New York State's veterans and their families and works to ensure that each of them receives the benefits they've earned as a result of their service. It's a pleasure and an honor to have him here with us today, so please join me in welcoming Sam Spitzberg.
Good morning. Thank you very much for having me. I appreciate it. I was thinking about coming here to the Brooklyn Law School today and how I ended up at Hofstra University School of Law, and it's because I grew up on Long Island. And like most kids who grew up on Long Island, our extent of knowledge about Brooklyn was it's where our grandparents were from, and it's how to take the Belt Parkway to get to the Verrazano Bridge to have to go and visit our relatives who have gone to New Jersey. And so when I was applying to law schools at the young age of 20, the thought of going to Brooklyn for law school never even entered my mind, because why would I want anything to do with traffic and things like that? So I never replied. I went to Hofstra, and one of my college roommates went to Long Island University and took an apartment over on Montague Street over by the Promenade. And I went to come and visit him one day, and right after he had graduated, it was the following fall, and I took a look at this. I said, "This is Brooklyn?" And he said, "This is Brooklyn." I said, "And this is where Brooklyn Law School is?" And he said, "Yeah, it's right there." And I said, "I have made a bad decision." And so I continued, though, because I didn't know exactly how to get out of the decision I'd made, and graduated from Hofstra. Now I look back, that young guy, and I realize now I'm that grizzled old attorney who all of us had when we first started out in practice. That person who was giving us advice and counsel, the person who was talking with us. I had a partner for whom I worked down in Atlanta, my first job out of school, who gave me a piece of advice with regard to dealing with clients. And he caught me talking to a client who had called, had a problem, spoke on the phone with the client, and I said to the client said, "Thank you." I said, "No problem." I hung up the phone. And Mike said, "Sam," he's from Atlanta, and he said, "Sam, can you come and see me in my office, please?" And so I go to see Mike in his office, and he said, "Sam, I can't charge for no problem." And he said, "Because it's no problem because of who you are and your skills. It was a big problem for the client, but because you said no problem, you have diminished your value as a problem solver, as a trusted advisor, as a counsel for this client. Don't take away from your education and your skills because you can't charge for no problems. It was a problem, you solved the problem. And so remember that as you're working with people, they've got a problem, they come to you as a lawyer to fix that problem and solve it. You take in that problem and you solve it for them. And then you charge them for it. Or sometimes we do it pro bono. So I'm working with Benjamin Pomerantz, who's in the second row here. And he'll, if he passes his background next week, he'll be admitted next week to practice. He's a recent grad from Albany Law, and he's working with the Division of Veterans Affairs, not a veteran, but has a great interest in this area. And it's giving me an opportunity to play the role of Mike Wood and be that partner now and try to teach him those old grizzled things. But I wanted to talk a little bit today about the important role that lawyers play in the lives and can play in the lives of our veterans. So, as Minor was saying, I was working here in Manhattan in Midtown, in the city, in the greatest city in the world, as a tax attorney, and I was running in Central Park one evening, and I was coming down around, if anybody runs in Central Park, I was coming down around 59th Street over by Columbus Circle, and I was coming down 8th Avenue side, and I said, "Man, I'm in pretty good shape." I was almost 30 years old, and I said, "I'm worth a lot of money to a corporation. I help them solve their tax problems, but I am absolutely useless when it comes to society. I'm not doing anything to help individuals, to help people." Hewlett-Packard was not my client, but as an example, Hewlett-Packard could save them a lot of money. I was good at that kind of thing. I was doing corporate restructuring and tax cases, but no value for an individual. And I decided I can go and do something different, so I decided to go and join the Army. And I had to convince my parents, of course, that it was a good idea. So I took them up to West Point with me, and my mother took a look around. She said, "Oh, this is what the Army is? This seems perfectly okay." And so it was 2001, I did my interview, and I graduated from basic in September of 2001. A couple of days after graduating, I reported to my first duty station, and it was September 12th, 2001. And for all of us who remember those dark moments, I walked into my boss's office, Lieutenant Colonel Fred Taylor, and I reported for duty, and I said, "Colonel Taylor, I'm from New York City, and they just knocked the front teeth out of my town. and I want to go forward wherever I need to go, into whatever division I need to go wherever we're going. And Colonel Taylor, he kind of looks like Captain America in every way. He's airborne qualified and has done every job in Special Forces and all tabbed out. And he looks at me and he says, "Spitz, you see my combat patch?" And normally, if those of you don't, you wear a shoulder insignia from prior wartime service on your right sleeve. And I said, "No, sir." He said, "That's because I don't have one." He said, "I've been in and out of division," which meant the 82nd. Throughout my entire career, I've been in SF units, and I have always been showing up at Fort Bragg right after the 82nd redeploys, or leaving right before the 82nd deploys, and I have never had that opportunity. Your job here, and it was at Fort Sam Houston, Texas, in San Antonio, it's a home of the combat medic, is to take care of our soldiers that are training. It's to take care of them, relieve any of their problems, solve their issues so they can concentrate on their jobs, which is to train and learn how to save lives. If you can take away their problem, if they've got a debtor-creditor issue, and you can take away that problem, you take it on yourself. You solve that problem for that service member. That service member is not going to be thinking about that debtor-creditor issue when he or she is training to learn how to save lives. You're going to be a combat multiplier, and you're going to save the lives of service members indirectly by relieving the pressure and allowing that service member to train and concentrate on his or her training. And I took what Colonel Taylor had to heart, and he said, "There'll be plenty of time and you'll get plenty of opportunities." And a few years later, I was in Baghdad, and lo and behold, my boss moved out, and Colonel Taylor, who was then stationed in Germany, showed up as my boss again, and so we both ended up with the same combat patch. But he's absolutely right. Our job in the service as a legal assistance officer, as a defense attorney, was to help our clients, to relieve their concerns and allow them to concentrate on what their jobs were. Get the skills that they needed, train, do their mission. In order to move forward once you get home, once you're out of the service, and in order to heal, you need to get through the morass that is the VA. That bog that wades and sucks you down sometimes to your kneecaps. And you carry it along with your ruck. And finding somebody who's going to help you and guide you through that system so that way you can put that away and start to heal is a great gift to those former service members, those veterans. So when you think about what a lawyer can do, if you want to help a veteran out, it's helping them through that VA maze is one piece of it. But it's all those other little problems that they have along the way. It's wills and trusts, it's debtor-creditor, it's landlord-tenant. It's all of those pieces of life. If you take those problems off and you make them yours to solve for those veterans, that's a great way of giving back. That's a great way of saying thank you, and allows that veteran to concentrate on what he or she needs to concentrate on to be a successful member of the society and give back and continue to be a giving member, a taxpayer, one of the best employees that anybody could ever have. So as you're thinking about what role you can play, the VA compensation and the work that Caitlin's doing, that the New York City Bar Association's doing, that the new law school consortium, that the New York State Division of Veterans Affairs and the Governor's Office is working on, those are pieces of it. But think about the totality in small-town lawyering of the client and solving that client's problems, taking them on yourself because you've got the skills and you can do it. A letter from a lawyer can go a long way. You've got the opportunity, the skills, the knowledge to do it. Please go forth, do great things. Thank you.
Thank you very much. So our first panel is going to focus on the bog that Sam Spitzberg described, the VA. And we're going to hear about the entire claims process. My role as moderator is going to be largely to stay out of the way. So we'll hear first from Caitlin Kilroy from the City Bar, and then from Nancy Morgan, who's at Finkelstein and Partners. And then we will open things up for questions to follow. So,
Is there a little? Oh, okay. Great. Should I stand or should I sit here?
whatever you want to put that.
All right, I'll stay here. So I'm from the Veterans Assistance Project at the New York City Bar Association. We run a pro bono clinic where we train attorneys from all the different corporate law firms around New York City who now want to maybe do something for society. We train them on veterans law. Oh, sorry. We train corporate attorneys from the law firms around New York City on veterans law, and then we run a pro bono clinic where low-income veterans from New York City come in, meet with those attorneys, and then those attorneys take on their cases for full representation. So I'm just going to go over some of the benefits that are available through the VA, and then Nancy's going to talk more about how to go about applying for those benefits. So first of all, who is a veteran? Not everyone who has served in the military is considered a veteran by the VA. The definition is a person who has served in the active military, naval, or air service and discharged or released under conditions other than dishonorable. So there's a bunch of different possible discharges you can have when you leave the military. There are administrative discharges and then punitive discharges. And the order is, there's an honorable discharge, general other than honorable, bad conduct, and dishonorable. And these, depending on your discharge status, will depend your eligibility for different benefits. So if you have an honorable or general discharge, you're going to be eligible for most of the benefits that I'm going to be talking about today. If you have an other than honorable discharge or a bad conduct discharge that was issued by a special court-martial, then usually the VA is going to determine that your service was not honorable, or it was other than honorable, but they're supposed to make an independent determination and look at the whole character of your service, and they have the discretion to decide that for VA purposes, your service is honorable and you can be considered a veteran. If you have a general court-martial or a bad conduct discharge for a general court-martial or a dishonorable discharge, then generally you're not going to be eligible for these benefits. There are other statutory and regulatory bars that apply here. So even if I had a case recently where someone had a general discharge but fell under one of those statutory bars, they wouldn't be eligible for benefits either. So the first and biggest benefit available to veterans is disability compensation. This is most of the work that the City Bar does. So disability compensation is compensation for disease, injury, or illness that began when the veteran was in the military. The disability is going to be rated on a scale from 0 to 100% in 10% increments, and that'll determine how much the veteran is compensated by the VA. And that number can be anywhere from $129 a month to over $3,000 a month. So for the low-income veterans in New York that our project serves, it can make a huge difference in their quality of life. Okay, so the elements of a disability compensation claim. There needs to be an in-service event that caused the condition. There needs to be a current condition that is severe enough to be disabling, and there needs to be a connection between those two things. So the in-service event, the way that you'd go about showing, the way that you'd go about showing the in-service event is you would look at the veterans' military records, their service records, any records they had from treatment while they were in the service, and see, evidence that the event that caused their injury occurred, or treatment for the condition while they were in service. If there isn't that evidence in the records. You might be able to fill in the gaps with a statement from the veteran or statements from people he served with. And there's one exception here. A veteran isn't eligible for compensation for injuries that were a result of his own willful misconduct. So if a veteran, was drinking and went for a joyride and got in a vehicle accident, you wouldn't be compensated for any of those injuries. There has to be a current disability. It needs to be current, meaning it can't be that, the veteran broke his leg while in service and now it's healed and not causing him any problems anymore. It needs to be something that's still affecting him to this day to be compensated. And the diagnosis needs to be by a medical or other professional. It doesn't need to be a VA doctor. The veteran can use records from his private doctor. And if the veteran isn't receiving health care or hasn't been diagnosed and files for a claim, the VA will schedule what's called a compensation and pension exam. Well, the veteran will go in and they'll evaluate whether he has the disability and how disabling it is. Okay. And then the nexus between the two. There are 4 different ways you can go about showing that there's a connection between the in-service event and the current condition. The first is direct service connection, which is, the veteran broke his leg and now has an injured leg and pain and limping. The second benefit that we see a lot of is non-service connected pension. This benefit is available to veterans who are either over 65 or under 65 and totally and permanently disabled, and those disabilities don't need to be as a result of their service. The benefits available to veterans who served during a period of war, which are set out by Congress, and it's a needs-based benefit. So if your income is over, it's about $12,000 a year. If your income's over that, then you're not eligible for this benefit. If it's somewhere under that, the VA will pay the difference between whatever your income is and the annual pension rate. There's a higher rate available for veterans who require aid and attendance or are housebound. You can apply for both compensation and pension, but the VA will only pay the higher of the two. In most cases, if you're eligible for both, that's going to be compensation. And I wanted to talk a little bit about interaction with other benefits. So a lot of the clients we serve are also receiving Social Security benefits. VA compensation, when you're compensated for an injury you suffered during service, it doesn't depend on income, so no matter how much money you're making, what other benefits you're receiving, the VA will still pay compensation, but pension is income dependent. So if you're receiving Social SSD, it can reduce or eliminate your pension. If you're receiving SSI, the VA doesn't consider that income, but SSI considers VA benefits income. So you won't lose your pension, but you may lose your SSI benefit. All right. And a little bit about survivors' benefits. Some survivors of veterans are have some benefits available. A surviving spouse who lived with the veteran continuously, can't remarry, or children under 18 or 23 and in school. There's 2 benefits, and they're sort of analogous to the compensation and pension benefits. The first is dependence and indemnity compensation. So it requires that the deceased veteran had a service-connected disability, either died on active duty, died from his service-connected disability, or was very highly rated for many years prior to death. And then there's the death pension, which is sort of analogous to the non-service-connected pension benefit, which requires that the veteran had wartime service, and it's a needs-based benefit. And this is even a lower rate than the benefit available to the veteran himself. It's about $8,000 a year. So the VA will only pay the difference between that and any other income. Finally, a little slide about why attorneys are needed in these cases. The VA process is designed to be non-adversarial, and the VA has a duty to assist the veteran in developing his claim, but it's non-adversarial, but for a long time, veterans didn't really have anybody helping advocate for them, so they couldn't really put forward the best possible case. Attorneys are also essential in gathering the records. A lot of times veterans don't know where to start, and a lot of the people that we serve have other issues in their lives. They maybe are struggling with housing, unstable housing situations. They might have other civil legal issues. So following up on requests for records they just don't have the resources to do it. And then also demonstrating the nexus. We have veterans who come in who have a condition that they're suffering from, and they feel that it was connected to their service, but they don't really have the ability to do, medical research or explain to the VA clearly why that should be service connected. So attorneys are essential in helping put forward these claims. Thank you.
You have to stand. How many of you are veterans? How many? We have a lot. That's great. How many of you practice in the veterans world? How many of you are lawyers who represent veterans or volunteers who help veterans or work with veterans? Great, great. My name is Nancy Morgan, and I'm an attorney who represents veterans in the private sector. There are about 620,000 pending claims. 68% of those pending claims are supplemental claims. You know what that means to me? They got it wrong the first time. If we do nothing else but help veterans with their claims when they first get denied, we can make a difference. We can change that number. We can help eliminate that backlog. 68% are supplemental claims. That's why I did it. My husband was in the service. I was an Army wife, 24 years of active duty, retired out of West Point, stayed in the West Point area, love New York. But my first love is I'm a personal injury attorney. You all know what people think of personal injury attorneys. But you know what? I help people every day. I help make the community safer. I help change people's lives, and I loved what I did. But in June of 2007, the law changed, and it allowed attorneys to help veterans in the administrative process, in the administrative fight, to help the VA get it right. And that's what we did. We're a large law firm. We put a lot of resources into it. I walked into the managing partner and said, we're going to do this. Went to DC, got trained, went to every possible CLE program like this that I could go to, and made myself competent in the area. And since then, we've been doing nothing but helping veterans day after day. I can't tell you how well I sleep at night and how good I feel when we get these decisions, the right decisions. I don't want to jinx ourselves, but we haven't had too many disappointments. We haven't had any disappointments, okay? If you do it right, if you help the vets, you can make a big difference. That's why I'm here, and that's why I'm doing it. Thank you so much to Minor for inviting us here, for Brooklyn Law School to make this commitment to help the veterans. I'm looking at Benjamin here. He made a cold call. How many years ago was that? 7 years ago, maybe? No, you're out of school just 1 year, so 4 years ago. I'm old. Time goes fast. Asked us to come up and help him in Albany Law School, to help them start a program. That program has just blossomed. We go up every year, once or twice a year, to volunteer to help veterans. They help dozens and dozens of veterans every year as a law school. Hofstra came up and learned from them, and now they have a program. I love that Brooklyn's doing it. We have 2 interns working in our office just across the bridge from Brooklyn Law School, learning from Christine, one of our attorneys, how to help veterans, how to appeal, doing research projects, because the Yale Law School has a great program just doing research. So there's a lot of things that you can do, and it's a really good cause. Sam talked about coming up to West Point to sign some papers, and it is the most beautiful place on earth. It's the reason we retired out of West Point. I love it there. And if you haven't been, you need to go, because it'll just inspire you to see those young cadets. My husband was there when the Gulf War broke out, and he wanted to go, and they said, nope, you've got to train the soldiers. You've got to train. You've got to support them. You've got to help them. You've got to train them. But what happens when they come home? We have to help them when they come home, too. So what I'm going to talk to you about is what happens to that veteran who comes back, has something wrong with them. Maybe they have PTSD. Maybe they have a broken leg. Maybe they have a bad back. But something's wrong, and they need some help. And we can help them get that help, because the VA has great benefits for those veterans. I want to distinguish something first. The first thing I want to distinguish is the difference between the Veterans Health, the VHA, and the VBA. The VHA is a hospital. That's going to give them medical help. They're going to get to go there and have the orthopedic treat them or their neurosurgeon do their surgery. That's the VHA. I'm not going to talk about the VHA. I'm going to talk about the VBA, which is the benefits that these veterans are entitled to. When you see a veteran on the street and they're homeless, if they're a veteran, they shouldn't be on the street homeless because there's most likely some benefits that that veteran could be getting that could help them, okay? So I'm going to focus on VBA. I'm not good at PowerPoints. The first thing that you have to find out, and the first thing you're going to have to do, and the reason when that veteran's calling you is probably because they were denied the benefits. They went on to va.gov or they went to their local regional office. Regional offices, there's one in every state. There's two in New York State, one in New York and one up in Buffalo. But they go to the regional office and they file their claim and they're denied for some reason. Usually they're denied because they couldn't prove there was service connection. Can I move this because I can't see this? I'm sorry. I don't want to be looking over my shoulder. They were denied service connection. And I'm going to talk details about how they get that service connection and what the different issues are. But they come to you because they've been denied. Well, what is it they've been denied? One of the things that you're going to look at is, it's very similar. Anyone do workers' comp law? Anyone know workers' comp law? You know you have the scheduling and they have different percentages for different things. Very similar here. They're going to get a disability rating based upon their percentage of disability based on a chart. So in 10% increments, they're going to get a monthly allowance, a check per month, based on the percentage that their disability, if they have a knee, or if they have a back, or if they have PTSD, or if they have hearing loss, it's all going to be based on this chart. And so this chart gets updated on a regular basis. So the first thing you're going to want to know from that veteran is, were you denied benefits? Were you awarded any benefits? And some of the things they want to do is increase their rating. They're getting 20% disability rating, and they think they're more disabled than that. They have a doctor that's going to support that, and they want to get an increased rating to 20%. So that's something that you can help them with in these increased ratings. And that's just the moving up this chart. And different things happen when you get to different ratings. If you get a larger amount, you get more benefits that are attached to it. We call it VA math. A lot of what you might have heard earlier this morning, it's a foreign language. I was never good at foreign languages. Thank God I was married to a military person for 25 years, so I understand a lot of the languages. But one of the things that happens is called VA math. VA math means 10 plus 10 plus 10 doesn't equal 30. The way they calculate their percentages, if you're 10% disability rating for a knee and you're another 10% for your shoulder, another 10% for your hearing, that's not a 30% disability rating. They take 10 and then they add 10, then it's 10% of that 20, of the 80%, and it's 10%, whatever it is. I'm not going to go through the math with you, but know that when the vet comes to you and they say, wait a minute, I had 10% for this and I had 10% for that, why don't I have a 20% rating? It's called VA math. And if you go to the VA website, va.gov, it'll explain that to you, and you can figure out what it is. I'm not going to go through it in this short time. But, for example, 50% plus 20% equals a 60% rating, okay? Now, I talked about the regional offices. Before June of 2007, attorneys were not allowed to help veterans at the regional office. And that's where the information is gathered. That's where the claim is defined. That's where the evidence is gained. And before that, and now, the regional office has a duty to assist the veteran. So they always felt that it was a non-adversarial proceeding, and you don't need lawyers in there, and they didn't let lawyers in there until June of 2007 when the law changed. And so for the first time ever, lawyers were allowed to help veterans. But then it became a little bit of a dilemma, and There were a lot of people before that did it on a volunteer basis. There are a lot of wonderful organizations out there for veterans that helped veterans up to that point. But I'm sorry, I'm partial, and I'm in a law school, so I can say it. I think lawyers can do a better job because we understand how to get to the concise issue. We understand, and I'm going to talk to you about what it is we're going to focus on. I'm going to tell you one or two stories. So in June of 2007, the law changed, and all of a sudden, we're allowed to have lawyers in the regional office helping these veterans when they get a decision that's not favorable. So what happens? The veteran goes to the regional office, or they go online and they fill out the initial application. It's a pretty standard form. They say what their disability is, and they make their application into the regional office. They get a notice back from the regional office saying, yep, we got it, we're going to process it. And now there's this gathering of information. They're going to gather their service records, they're going to gather their medical records, they're going to look for if they have any outside the military medical records, they're going to start gathering all this information. And the veteran can also submit a lot of information, and we find they like to submit a lot of information. They get buddy letters, they get all kinds of things, and that's all submitted to the regional office to the regional office. At some point, regional office makes a decision. They have the rating decision, and that's sent to the vet. That's when we get involved. That's when the phone rings. Because if that decision is not favorable to that veteran, if that veteran's not happy with that decision, the veteran can now call a lawyer, and now the lawyer can help them in the process of, quote, appealing, but I'll give you more details, appealing that decision that was just made. So how do you appeal the decision? You start with something called a notice of disagreement. That's the term that they use in this world. Notice of disagreement can be simply a letter, if the veteran sends it or if you send it, that just says, I disagree with your rating. We like to be a little more detailed. If you're an attorney writing a notice of disagreement, be careful, because the VA is not too happy having attorneys in there muddying the water and mucking things up. So when you do your notice of disagreement, be clear and concise. I think I might have given you some examples in there, but if I haven't, send me an email. My email's in the materials, and I'll get you some forms and some copies of some notices of disagreement. So you're going to send in your notice of disagreement. You're going to let them know you disagree. Then there's a lot of different options. I'm going to give you those details in a minute. But at the regional office, if you're not happy with the decision, the next level up, still in the administrative world, is called the BVA, Board of Veterans Appeals, where you're going to appeal that decision. Again, lawyers weren't there before, they're there now. And what you're doing is you're going to go, you can go to a hearing in DC, and I'll give you the details, but you go to the BVA. So it's the regional office, then it's the BVA. If you're not happy with the BVA's decision, you can go to the CAVC. CAVC is the Court of Appeals of Veterans Claims. And if you're not happy at the CAVC, you go up to the federal court, and you can go like to the Supreme Court. So that just gives you an idea of what's happening when that veteran calls you and tells you that their claim has been denied. So you've gone through the regional office process. You want to appeal it up to the BVA. What happens? You go to the BVA, you get your decision, you ask for them to reconsider, you go to the BVA, you present your case to the BVA. You can have a hearing in Washington, D.C. You can have a traveling hearing. I think I have that on another slide. There's different ways of handling the BVA. You can do a video hearing. They have judges that travel to the different regional offices. You can have a BVA hearing there. And then if you're not happy with the BVA, you go to the CAVC. This chart is in your materials if you have the materials. It's a convoluted chart, and I'm not going to go through it today. But I want to give it to you because when I first learned back in 2008, the beginning of 2008, someone gave me a chart like this. And I taped it next to my computer so that I could look at this chart and say, okay, let me see. If I'm at the regional office, I can go here. And if I'm at the BVA, I can go here. And here's my choices. And this will give you the deadlines. You have some deadlines you have to worry about. I'm proud of our firm. We helped an organization called NOVA, National Organization of Veterans Advocates, do an amicus brief for a Supreme Court case called Henderson, which helped fight the 120-day period for the CAVC. I won't bore you with the details. But so these numbers, deadlines are pretty firm, but there's ways around them always. what are the types of claims? And Caitlin did a good job of talking about the different kinds of claims, and I'm not going to go through them specifically, but just so you understand what you're looking for, if there's a denial, what are the kinds of claims that you're looking for? Well, direct service connection. You know, I jumped out of an airplane and broke my leg when I was in service. I currently need a knee replacement, and my knee was damaged back then, and I have a doctor who says this knee replacement is causally related, or the nexus with that fall or that jump out of the airport. That's all it is. That's a direct service connection. Secondary service connection, a lot of times it's diabetes. You have diabetes, which is service connected. My husband has diabetes. He got it while he was in the service. So now when he has some other things, neuropathy type things, that's a secondary condition related to the one that was connected. A case to reopen a new material evidence, I'm going to talk about that, is another way you can open as a type of claim. Increased rating, I have a 20%, I want a 40%. TDIU, total disability, if I have time, I'm going to talk a lot about that, because as a lawyer, that's the most rewarding thing we can do for a veteran. And the VA must consider all the theories when they're adjudicating a claim. So service-connected disability, do they have veteran status? Caitlin told you about that. Do they have a current disability, a current diagnosis or disability? That comes up a lot with your PTSD cases. You need to have a doctor that says PTSD, the magic words, because VA might say it's something completely different. You need the in-service event, you need medical evidence or link, nexus opinion. They're the three things you need. Caitlin also talked about as likely as not. As a lawyer who's done personal injury law for 25 years, I love this burden. As likely as not. Not more likely than not, as likely and not. Get on the phone and talk to their current treating doctor and say, doctor, is it fair that this is as likely as not from that event in service as it could be from their subsequent injuries or subsequent treatments? And most medical doctors are pretty comfortable with that. They're not comfortable with saying it's more likely than not. But that burden, that's a legal thing that we as lawyers can just pounce on and hammer that home when you're writing your papers and when you're helping your veterans. So, again, always goes back to current diagnosis, event in service, nexus opinion. These next slides are all going to be about that, okay? If you can, one of those three things is missing. That's why your vet came to you. That's why they've been denied benefits. One of those three things has to be addressed. Let me give you one story. I went down to DC, I think it was about a month ago, for a veteran who had been fighting for probably 10 years, maybe 15 years. He's a Korean War veteran. He claims to be exposed to Agent Orange. He has the current conditions. He has a nexus opinion, which we had to work with a little bit, but he had a nexus opinion. But he couldn't prove the event in service. And he didn't fall into that presumptive time, because there has now been decisions that there are some Korean vets that were exposed to Agent Orange. And he kept saying, but I was exposed, I was exposed. Well, how do we prove it? Well, his testimony, he gave very detailed testimony that he was on a DMZ zone while they were spraying this exfoliant to get rid of all the growth, and he kept doing it. But guess what? When I was with him, he happened to pull out a picture. There was a picture of him on the DMZ, standing there with a truck behind him, and it totally 100% supported what he had been saying for 10 or 15 years. And we walked out of there, and the judge said, well, this is like an easy one. We still haven't gotten the decision yet, but I'm pretty confident that this was going to be an easy one, because now we could show his feet were he was in the picture standing there. You could see there was no vegetation for miles. And on the other side of the fence, you could see the high vegetation. So just finding a picture. Another vet who said he had broken leg in Germany, didn't have any proof because it was a German hospital. We couldn't get proof of it. He found a picture of him sitting on the ledge with his cast, at Christmas time. So little things like that you're going to have to find to help them come up with it. Effective date. That's very, very important for me as a lawyer. I know there's talk about contingency, people who are contingency lawyers taking money. Well, I see it as allowing access to justice, allowing access to legal care. Because those vets can't afford to pay me, I need to be paid to be able to cover the overhead and the employees, and we're not making a killing in this, we're just paying our bills. But the contingency fee that you're allowed to charge without real question is 20% of past benefits. So when I'm not doing pro bono and when I'm charging a veteran to do the work, and we have a pretty solid national practice, when a veteran calls us to ask us for help, we tell them, I'm not going to charge you, but if I'm successful and if I get you your compensation for your disability, my charge is going to be 20% of your past benefits. So why is effective date important? Well, the VA might say, yup, we agree with this vet who's been fighting for 10 years that you were exposed to Agent Orange, and your effective date is now because this is what we agreed to. No, the effective date is the very first date he put in that claim 15 years ago or 10 years ago for that exact issue that they've been fighting him for 10 or 15 years. So that vet should get a very large check to compensate him for that fight that he's had. The effective date will be 15 years ago. My fee will be 20% of that past benefit. That's not a normal case. The normal cases are, they're 2 or 3 years old, they've been fighting him for 2 or 3 years, they were increasing the rating from a 20% to a 40%, and they're the more typical type cases. But the way that attorneys get paid in this field is 20%. Another way is that if you, remember I said there's a regional office, the BVA, the CAVC, and the federal court. Once you get to the CAVC level, there's something called EJIA fees, equal opportunity to equal access to, whatever, EJIA fees. The EJIA fees pay you hourly, a reasonable hourly fee. So even if you're doing the job pro bono at the BVA level and you appeal it up to the CAVC level and you win at the CAVC level, you're entitled to reasonable attorney fees. So they're the two ways that attorneys get paid on these cases. Remember I told you that those deadlines for filing are pretty soft deadlines, that there's ways to find that you can do. You can get around them sometimes. The clear and mistakable error is one of them, and new material evidence is one of them. If your vet has they've denied him benefits, and he has new and material evidence, a new orthopedic just took an MRI and said, oh my gosh, there it is, I see that herniated disc with impingement, or something new, you can reopen a claim for new and material evidence. The other one is called clear and unmistakable error. That's Christine's specialty. She loves those cases. You go back and you look at that C file, which is what you have to get when you're representing a vet. You ask for their claims file, and the VA, for free, one time, sends you their entire file. We're paperless, so we scan it all in. We now have access. We give our vets a disc, so they now have it on disc. And one of the things you're looking for in that claims file, that fight that they've had for the last 10 years, is the mistake. What mistake did they make? They're hard cases. But as lawyers, you can really go through that information and say, wait a minute, you said there was never evidence of such and such, and here it is. It was right here in this application or in this medical record, and you missed that. This is a little more detail of what I was talking about. Another one of these charts. This is the traditional process benefits flow chart. So just let me take you through it really quickly. File your claim with the regional office. It's either granted and processed or it's denied. If it's denied, you file that notice of disagreement, and then the regional office gives you a statement of the case. Once they give you a statement of the case, that lays it out, okay? The next step is to file a VA Form 9, and and you get it certified to go to the BVA, or you can ask for a review at the regional office level. You can say, they have a review officer at every regional office. If you want a fresh look at your regional office, you can go to that DRO. We do that. I know a lot of lawyers, I've listened to a lot of speakers say they never do that, it's totally wasted. It's a timing issue, and it's what you think you can do, okay? If you think that you can just lay it out for this DRO and go back and have them fix their decision, it's a little faster than getting into the quagmire of the BVA and waiting forever the BVA. You know, but that's a call that you can make. You can go either direction. And then this tells you the rest. Just go all the way up. If you go to the DRO process, that's what I was just talking about. This tells you how it works. This is that statement of the case. It can be appealed to the BVA. The statement of the case lays it out. As a lawyer, you should be able to read that and pick out what it is they missed or what it is that they're not seeing, and then help them with that. The BVA, so Form 9, you have 60 days of the statement of the case. So when you get that statement of the case, that's a tight 2-month period, 60-day period. And this just takes you through that process. You have 120 days from the BVA decision to get to the CAVC, again, for deadlines. You go to the Federal Circuit, again, 60 days is the decision, is the time to file the appeal. And that's it. So that gives you an idea of the process. So that gives you an idea of of what happens when a vet comes to you when they've been denied benefits. Help them out, and what was said earlier today, you can help that veteran in a lot of ways. If a veteran comes into you for Social Security disability benefits, ask them if they're a veteran, because it might be relevant, and they might also be entitled to some VA benefits. If they have a disabled individual that comes into your office and they're a veteran, find out where that disability came from. Find out if they had time in service. We have these young men and women that are volunteering to serve our country. When they get out of the military, when they get out, they need our help too. So that's it. Thank you.
Thank you, Caitlin. Thank you, Nancy, for a fantastic overview of a very complex process. Why don't we take some time now to open things up for questions, for discussions with our panelists. But anyone who has a question, sure, stand up so we can hear you.
My question is this. I have a lot of problems with the DFW there. The backlog in reverse stage is so immense. Sometimes it's 5 years, sometimes it's 10 years. Is there a way a lawyer can push the process on the original claim that a veteran has instead of lost in the backlog or the regional office? Because the regional office came in because there were so many files.
That's a great question, and I can take that one. I think the hardest thing in this practice is telling the veterans that I don't have control over the time, because it takes a long time. But what the best way for you as a lawyer to do it is when you submit that claim to make it a fully developed claim. As long as it's a fully developed claim, they say that it's going to move faster through the process than if it's a claim that they have to develop. So that's the only advice I can give you is when you're representing that veteran, before you file that claim, file it as a fully developed claim. Have all your evidence together, have everything put together, and make it really easy for them to make that decision so that your case will get decided faster than that case that's going to take them a lot of work.
There are also ways to expedite. No, thank you. Though it's rare. You can expedite for financial hardship or for health reasons, but most of the clients that we serve are in pretty severe financial hardship, and that's kind of not enough. But if a client has, like a terminal illness, I have seen cases move very quickly, which very quickly means 2 or 3 months still.
More questions? Yes.
Yes, you talked about the formula on benefits being received, such as, for example, I have a 40% disability for one injury. I have a 20% disability for another injury, which would give me a total of 60%. However, the papers read 40 and 20, and I have 70% disability. How is it to count the additional 10% based on you said it would be 10% less?
Right, and that's really VA math, but in your favor on that case. I don't have an answer to that, but 70% usually goes to how it's affected your life. I mean, and I don't have an answer to that. I would have said the 40 plus 20, it's 40%, and then 20 would have been 50.
Even there, mine is not based on these.
Okay, right. Well, none of them are. There is a pension, which I don't think either of us talked about. I know I didn't talk about it. There's a pension benefit that's based on need. Nothing else is based on need.
A pension benefit is not based on it.
Your disability payment is not based on need, right, correct, correct.
Therefore, if it is not based on need, normally you would say, if you have medication you require, VA, you would have copay. Why have no copay if it's not based on need?
Right, right, that's because of your 70%.
Well, some would be even less if they have received a medical law, for example. Automatically, there's no copay.
Right.
Now, as far as the compensation is concerned, counselor, who adjudicates that? Who sets the compensation?
The fee, the attorney fee?
Yes.
The attorney fee, if you collect 20% of past benefits, is paid directly from the award. They withhold that amount of money. They hold it for, I think, 30 days or 60 days. They take out a $100 servicing fee, and then they send it to you directly.
So that the fee is based on the increase that you receive as a result.
All right, let me explain that. Here's how it works. So if you're getting an increased rating from a 20% to 30%, it goes back 5 years, and my 20% past benefit fee is $1,000. The VA would hold out that $1,000, give the veteran their, whatever, I don't do math, but that other amount of money, hold out our money for 60 days, and then pay us directly. And it's based on 20% from the effective date up until the date of the decision.
So that's based on the lump sum that they've received.
Correct. For those of you that couldn't hear him, he was saying that that 20% is based upon the lump sum that you received, and that's true.
The increase.
Yes.
So that if the increase will continue, say, the person lives another 40 years,
We don't take a fee on any future benefits. So from the date of the decision forward, it's 100% their money.
how about those records when you have to prove the case? The records that were destroyed by the big fire.
That comes up a lot in a lot of our cases. For those of you that don't know, there was a huge fire that all the records were destroyed in this fire, and because of that, the presumption's in favor of the vet. We've had some good luck getting secondary information, buddy statements, and things like that to overcome that, but it was a problem. It's becoming less of a problem as we're getting older.
We've also had luck in our project in finding records that were destroyed in the fire. With like a little bit of advocacy, they can be found sometimes.
Let me ask a question about the role of doctors. This seems such an extraordinarily complex area of law that I can't imagine going through it without the assistance of a lawyer. But so much of the success or failure of any particular claim at the initial claim stage or in the appeal seems to turn on what the doctor says. Who are the doctors who are making the determinations about disability and the nexus, and for someone who sort of needs not just the help of a lawyer to go through it, but access to a doctor? How do you deal with that?
Most of our clients are receiving health care through the VA, and I've actually found, I guess because they're different systems, the VA doctors are really very willing to work with you, very willing to write medical opinions, and help advocate for the client. We have some clients who aren't eligible for VA health care because of their discharge status, so then it's a little bit more difficult to get them care. They might be eligible through other programs, they might be eligible for community clinics or sliding scale type things, but that's an issue sometimes. But
We
most
find the
are
same
good.
thing.
Yeah.
We find the same thing. I'd say probably 70-80% of our veterans are being cared for from that VHA, from the Veterans Hospital, the system, and they're very helpful, and they understand the language that we need. When you're dealing with private practice doctors, the problem is they're great doctors, they don't understand the veteran the words that the VA needs. For example, they want them to say, I looked at the C file, or I reviewed those records. And those doctors are saying, I don't know what that is, even know what that is. So we have to provide them parts of the C file and say, please state in your narrative that you've looked at this C file that and this is the C file that we're giving you. You know, but most of ours are VHA.
Questions of mine? Wait.
I want to build on Minor's question for just a second, your experience. So, when you have a civilian doctor who's giving you your B, as likely as not opinion, and you have a VHA doc who's treating the veteran, and then you have... Thank you. So the question is, when you have a VHA doc that's treating, and you have case notes, and you have a civilian doctor that's treating and has case notes and can give you the as likely as not opinion, and then the veteran gets sent to a comp and pen exam, which is a VBA doc, still inside the VA system, how do the raters evaluate then the different opinions between the VHA doctor that's been treating the person for years, the civilian doctor has been treating for years, and the VBA doc that may spend 15 minutes with the veteran and gives a contrary opinion?
I'm happy to handle that one, because it's very similar in the PI world as it is here. You know, it's an insurance company sends them for that 15-minute independent exam, the VA setting them for that CMP exam, very similar. Your job needs to be to make the report of the treating doctor and/or the VHA treating doctor to be stronger. And the way to do that is to help them with language. And the way you help them with language is look for objective evidence. For example, range of motion. That's a simple thing. Range of motion or spasms, or, you know, identification of spasms, or any objective evidence that those doctors can identify. And then you, as a legal advocate, have to write in your papers why that treating doctor who has seen them 24 times over the last 4 years has objective evidence on 15 of those times that shows spasm, that show limited range of motion. On PTSD, it's a little tougher, but you have to come up with the elements in those reports, and you then have to be an advocate and explain why. The way I cross-examine a doctor in a PA case on the stand about them having secondary motivation, you have to do the same thing. So it's really about you being an advocate, and exactly what you just did with your question, do that in your papers, and tell them why it's ridiculous that they would accept that 15-minute independent CMP exam and ask for a second CMP exam. You know, but it's really advocacy. It's tough. It's a tough thing, because they're going to listen to the CMP exam. I mean, and then you're going to fight them again.
There's also some stuff you can do to try to prepare your client to go into the
Yes.
CMP exam. So if you have records that you want to make sure, that the doctor is looking at, they're supposed to have their claims file in front of them, but you can maybe give your client a little packet of the important records to show the doctor. The doctor may or may not take them, but have those ready. Get your client ready to answer questions. Also, like, a lot of times, you know, let them know not to exaggerate their symptoms, but also not to downplay their symptoms, because sometimes they'll go in and the doctor will say, how are you feeling today? And they're feeling fine that day, so I'm great. And then, you know, they don't get a proper evaluation for their post-traumatic stress, which on another day is very debilitating. So to have them talk about what an average day is like for them, no matter how they're feeling that day. A lot you can do to prepare so that the CMP exam is also in your favor.
That's great, and I forgot that, that's great. Absolutely, we send them with the records from their doctor. We, you know, have them bring it with them and prepare them.
Additional questions? Yeah, someone waiting patiently.
Hi, just as far as, I guess, the disability compensation benefits, that's post-tax? The numbers you had on the board?
No tax.
No tax,
Yes.
okay.
Mhm.
And then, as far as, is there a spousal benefit, a surviving spouse benefit on the?
You're paid at a higher rate depending on whether you have a spouse and how many dependents you have. It'll change the rate that you're paid.
Okay, so it was basically, I saw on the pension, it was 12,000 for the vet and then 8,000 for the surviving spouse. Is it basically that same number for disability comp, or?
So those are two different benefits.
Right,
The
understood.
disability compensation, I think Nancy had a slide that had sort of the whole range. So it depends on what your percentage rating is, and then if you have a spouse and how many dependents you have. The pension benefit and the death pension benefit are needs-based. So those are sort of set numbers that will depend on the income that the eligible person is receiving. It'll offset that number.
Okay.
Yeah, sure.
Just a quick one. I want to, Caitlin, City Bar Justice, Hugh and Coco, you've been like fantastic partners with the mayor's office. You guys are always great. I just want to say that to you. I just attended a meeting at the VA regional office, and the fully developed claims, they seem to have a turnaround time of about 5 months plus. And so the numbers are there. I'm sort of like right there with the approximate numbers. What I would say is that at the mayor's office, I have to service every veteran that walks up to the door, regardless of condition of discharge. The VA essentially does not. Okay, so that's when we run into some problems, and we have to try to figure out, what we can do to help them in city services, et cetera. But what I would say is that there are a couple of situations, and you're the experts and I'm not. Military sexual trauma, the VA must accept everybody who walks through the door where there's an assertion of military sexual trauma. It's my understanding that any other things that are unrelated, they will not treat, but they will treat the military sexual trauma. So if you have somebody who has less than an honorable discharge, the VA has got to take action. Also, there are a couple of situations where the VA will service, is supposed to service general discharges, and they just get, in the interview process, they just cut people off right away. So I think that as advocates, you need, if the decision is wrong, you just need to plow on and keep climbing up the ladder till you find somebody who goes back and reads the regs and provides the service. But again, thank you all very much. It's just wonderful.
Thank you, thank you.
And that was Commissioner Terrence Holliday from the Mayor's Office of Veterans Affairs, so we'd just like to thank him for joining us.
Hi. Caitlin, you mentioned how Social Security disability benefits could reduce or eliminate VA benefits. Is there a formula, or could you elaborate on
That's
that?
just for the VA pension, which is the needs-based benefit. So that, the VA pension, if you're receiving that, or if you're a survivor receiving death pension, any other income will reduce that benefit. So any other income that you're getting will offset the VA pension, including Social Security disability. Social Security, SSI, Supplemental Security, is a needs-based benefit as well. So if you're receiving that benefit, it's sort of like the VA doesn't count SSI as income, but SSI counts any VA benefits as income. So if you're receiving VA compensation or VA pension, you might no longer receive your SSI benefit. Yeah.
I understand that the VA must approve any attorney who wants to practice before them.
Well, let me tell you what the standard is. First of all, you must be an accredited attorney.
But that's not my question.
Oh, okay.
My question is that once an attorney has filed an application to be approved before them, how long...
Could you put the mic?
Okay, I'm sorry. Once an attorney has filed an application to be approved, how long does the application process take?
Okay. The application to be an attorney for the VA, to be approved as an attorney for the VA, we've done quite a few of them in the last few years, and it's taking a little longer now than it used to, but it was pretty quick. You put in your application, within 6 weeks, you should have an answer, at least that's what we were getting. Might take a little longer now, they've had quite a few attorneys doing that, but once you then get that letter back, the letter is going to say, you're now accredited to represent that veteran, but you have to take 3 hours of CLE within that next year's period. So you have to, within that next year, take a course like this that qualifies as a CLE requirement. But that's it. And it takes about 6 weeks. Doesn't take long. So anyone here that wants to represent veterans, you can't represent them unless you're accredited. And to be accredited, go on va.gov, get the application, fill it out, mail it in, and it's about 6 weeks.
So I think we have time for one more question.
I have two questions, actually, but the first is, can you get VA benefits if you're working? Does that affect your ability to
Yeah,
obtain
disability has not, yes, the answer is yes, short answer is yes. If you have a disability, my husband is the headmaster of a school right now, and he has 70% disability. So yes, you can work, there's no comparison, it's not need-based.
And then the second part of that is, the rate that you're getting, that's not based on how much you're making at the time you were in service, it's just a flat fee? Is that correct?
The amount you get is based upon your injury. So if you have a torn meniscus with surgery, you're going to get a 10%, 20% rating. If you have a knee replacement, you're going to have a 100% rating. It doesn't matter what your salary is, doesn't matter anything. It's based on the injury and the effect that injury has on your life.
So we've reached the end of our first panel, and we're going to have a coffee break now for 15 minutes, but we'll reconvene
Hear
then.
important questions.
Sure, when
May
we-
help lawyers.
At the break, why don't we, you can ask me at the break, okay? That'd be great. I'll come and take your
So
question.
please join me in thanking our panelists.